Okay, we're on House Bill 46 by Chairman James. Mr. James, on your bill.
Thank you, Mr. Vice Chair, members. Members, I wanted to come down to the table with House Bill 46 because it's what I believe addresses one of our most serious due process problems in the state. Today, under current law, a person can be arrested, and the Code of Criminal Procedure allows that person to be held in jail for up to 120 days without being charged. Even in some of our very minor offenses, our law allows that person to be held in jail, again, without charge for up to 45 days. That's a month and a half away from a job, away from children, away from anyone else that depends on that person. Again, being held without charge. Over a period of 120 days or 45 days, people can lose income, they could lose homes, and we know that extended jail stays only make it harder for people to get back on their feet. Additionally, millions of our hard-earned tax dollars are going to house many individuals, again, without charge. A lot of people never have charges filed at all, and they end up being released after weeks of unnecessary jail time. Let me be clear about this bill. The timelines that this bill deals with come before any criminal charge is filed. This bill has absolutely no effect on the prosecutor's ability to ultimately file charges against a person regardless of the timelines. This bill does not take away any of the good cause provisions that consider natural disasters, emergencies, or other circumstances beyond the control of a prosecutor. That part of the law remains untouched. This bill also has no effect on a judge's ability to set a bail or other bond conditions. What this bill does do is provide that we should not, or set the tone that we should not hold people in jail for months without being charged with a crime. Now, my bill will reduce the charging timelines to 5 days in most cases and 30 days in the most serious cases. And I'll tell you that I watched in my parish, our district attorney operated about 2 months where his ADA is charged in 72 hours. So I know that this can be done. And I'm not going to sit here and say that it was easy, but I know it was done, and it significantly reduced our jail population here and cost taxpayers money. It was able to save taxpayers money, and we were able to quickly get folks out of jail that had been arrested. The stakeholders that you'll hear from, mainly the ACLU, they worked almost 2 years on this legislation. So this is not something that we just brought to you today without significant thought and significant research. It's important to me because I think that this bill gets to the heart of one of our most fundamental constitutional rights, and I think that is why this bill has brought support from right, left, civil liberties groups, and other advocates. One thing that we have done in this process, we've had several conversations with the district attorneys, and I want to thank Lauren and his team for the ongoing conversations that we've had regarding this bill. And to that effect, there are some amendments that I want to present that were birthed in those conversations that we've had with the district attorneys. I'm not going to say that it removes all of their concerns, but I think that we were able to address a significant number of concerns that we've been hearing over the past few weeks.
Mr. Chair, would you like to offer those amendments?
Yes, I'll
now?
offer.
Okay. Would you read the amendments, please?
There you go. This is Amendment Set 1327, and what it does is makes technical changes to the citations. It removes the provisions relative to subpoena of witness to appear from the bill. And with regard to the appearance for purpose of appointing counsel, it changes the condition for which the court is required to assign counsel from being based on whether the defendant has the right to being based on whether the defendant has been determined to be indigent. And it adds that the preliminary examination shall be conducted no later than 2 weeks, exclusive of weekends and holidays, unless the defendant waives such timeline or just cause for delay. It also provides exception to releasing the defendant when just cause for failure to institute prosecution is shown after the contradictory hearing with the district attorney, and it also adds an effective date for January 1st, 2022.
Chair.
Yeah, thank you, Ms. Becknell. And I'll just kind of lay out 4 quick points on the amendments. Number one, we heard various concerns about the subpoenas under Article 66. So we eliminated that section of the bill. Second, the language clarifies that a prosecutor can seek an extension on the charging timeline for good cause. And it's just like current law, but the amendment makes it unambiguous. So I think that the amendment clarifies and clears this up. Third, we have language that clarifies the right to counsel for indigent defendants. And finally, we move back the effective date, recognizing that we want to give district attorneys across the state time to review their policies, time to come together with the appropriate stakeholders to make any necessary changes to make sure that we aren't employing some type of undue burden on the district attorneys. We have several witnesses here who have worked on this issue for, like I said, almost 2 years now, and I'd like to give up the chair at this point to some of the witnesses that are prepared to speak. If you guys don't have any questions.
Well,
for
I
me
think first we need to, do you want to adopt the amendment set?
Sure.
Okay, we have a set of amendments offered up by the author. Is there any objection to the adoption of the amendments? Seeing no objection, the amendments are adopted. And Mr. Chair, we do have a Representative Marcel would like to ask you.
Okay.
Okay. Okay.
Thank you.
Next one. Who do we have?
We have I want Meg Garvey and Miss Stephanie Willis.
If y'all would take the table while the chair returns to the chair.
Going first, or are you stuck? You go first. Okay. Good morning, Megan Garvey again on behalf of LACDL, and I am here in that specific capacity, and LACDL collaborated with ACLU on this bill because we do believe, as Chairman James said, that this is a very important problem in our procedural rules that needs to be addressed. And I will also just submit that I am a public defender and have been so for many years. So this is an issue that I have wrestled with throughout the years. So we're here in favor of HB 46. And I just want to also point out that we have had a lot of conversations in this committee, and the representatives have brought a lot of bills addressing the concept of justice reinvestment and addressing the idea of over-incarceration and addressing, how can we shorten people's time on parole and probation and shorten people's sentences and really get things, get people back to where they need to be in the community. And I think this is an excellent opportunity to address all of those kinds of problems, but focusing on people who haven't even been convicted of a crime, people who are innocent under the law. And so at this point, I just kind of want to take a little bit of a deeper dive into the nuts and bolts, just to remind people of the process and how this law affects both people who have been arrested and system players every step of the way. So obviously we start with an arrest. And when somebody is arrested by law enforcement, that is not a formal charge. Oftentimes, it sort of depends on jurisdiction to jurisdiction and which law enforcement entity is doing the arrest. But sometimes the only information that's presented is a short affidavit, perhaps just like a little paragraph, a few sentences sworn to by a police officer. And oftentimes, it's just that much information that is present when somebody goes to jail. But before we get to that, people have the right to have a first appearance before a court. This is very inconsistent procedure across the state. And sometimes, in some places, they have first appearances 3 times a day, every day, on holidays and on weekends, right? So it's a much more fast turnover in order to be able to appear before a judge. But some places, it's only, you have 72 hours and that's it, and they don't meet every day. In some places, you actually come to court and it's a regular courtroom and you are seen before a judge. In many places, it's over video. In most jurisdictions across the state, district attorneys are not present for these hearings, and neither are public defenders. And so it's quite possible that you get arrested based on the affidavit, maybe just a couple sentences. You go for your first appearance before the court. The judge finds probable cause based on just those couple of sentences, and then you're sent to jail to await a charging decision by the district attorney. So at that point, it's quite possible that no district attorney and no defense attorney has even reviewed any of the paperwork that's put before you, and off you go. And we know, and we heard from Chairman James, went through all of the terrible impacts this has on people's lives. Some of those are irreparable. People are often made homeless because they cannot afford their bond, and they lose their jobs, they lose their homes. Sometimes people, custody of their children is placed in jeopardy. People fall behind in their medical care, their mental health care, their education. But beyond that, and keep in mind, this is just a probable cause standard. There's no beyond a reasonable doubt at this point. It's just, are you the same person that somebody is accusing of this charge? Also, I just want to make clear that there are case impacts that this time period impacts as well. So it's not just people's life outcomes, but it's definitely negatively impacts their case outcomes. Evidence gets lost over time. So evidence that a defendant could marshal to help defend themselves, that can fade away. Access to witnesses, that can fade away for defendants. And also, oftentimes people end up pleading guilty, because once you've sat in jail for 6 months, 2 months, you're going to be more likely to just go on ahead and go with whatever process is going to get you out of jail. So it does increase the likelihood that people are pleading guilty to things which they are not guilty, pleading guilty to charges that are not the accurate charges. And it also limits the likelihood that there are going to be problem-solving sentences or problem-solving courts involved. It's usually going to be some kind of credit for time served plea or short probation or something like that, just to kind of move along with the process. And it's going to be less likely to be a diversion or, participating in a program. And also, that person is going to be very unlikely to be able to pay restitution to any victim because they've been made a pauper by virtue of sitting in jail. So during the screening period, from the point of view of the defendant, what's happening? Often very little. It depends on certain factors, right? Obviously, whether you can afford your bond or not is a major one. But beyond that, you can't file motions on your behalf because there's no court case to file motions in. You can't get discovery because there's no case yet. Oftentimes you can't investigate properly because you don't even have enough information about the case to begin an investigation as a defendant. And that's if you even have an attorney. Additionally, oftentimes you can't subpoena certain documents that you need, that you might want to preserve. Sometimes there's surveillance that you might want to preserve. We've had examples of that, and there are some provisions in this bill that are meant to address and protect those pretrial rights for defendants as well. You don't get to cross-examine witnesses. You can't really negotiate resolutions. You're just sitting. You're just wasting your life. And then the charging process, there's 2 different modes of charging in Louisiana. Indictment obviously can be a little bit more complex, which is why this bill allows for more time for those cases where the prosecutor has to bring in a grand jury. But normally it's just a bill of information. A bill of information is a document signed by a district attorney that simply alleges that a person committed a crime. And HB 46 really lessens all of these negative impacts, not only on people's lives, but on their cases and their inability to access due process by shortening that period of time, by letting people sit in that sort of like limbo, purgatory kind of place for a shorter period of time. And that's why we brought the bill, and that's why we think it's a good bill. But I also just wanted to echo what Chairman James said about, I know that we do have our colleagues from the LDAA here who do have some concerns, and we had gone back and forth with making several amendments to try to address some of their concerns. And I do know that they have concerns about resources and perhaps a lack of resources that they need in order for things to move more quickly. But I will say that, I've talked with my colleagues from ACLU, and I believe that, we would be happy to include provisions in this bill that address some of the concerns that the DAs have. For example, if they need to have timelines to make sure that police reports are done within a certain period of time, we can work on that. If there's things that we need to figure out with the crime lab, we can work on that. But the bottom line is we have to start moving forward now, because it should be the system players, the people who work in the system, who've chosen that as their job, and the legislature that come together to solve these problems, rather than letting people who are innocent before the law, just regular Louisianans who get arrested, rather than having them pick up the slack. So that's why I'm here in support of this bill, and I would ask for a favorable passage.
Thank you, Ms. Garvey. Ms. Willis. Mrs. Willis.
Good morning, Chairman James, Vice Chair Bacala, and members of the Administration of Criminal Justice Committee. Thank you for having us here to speak on behalf of this courageous bill. My name is Stephanie L. Willis, and I am the policy strategist for the ACLU of Louisiana. As a former prosecutor, I know and understand that DAs make a difference and an impact in people's lives, in their communities, and the criminal legal system. As a former prosecutor, I also saw firsthand the timeline of a case brought into our office. Through the screening process, I was able to dictate the course of someone's life even before the individual was charged with a crime. It was my job to hold accountable those who violated the law, but it was also my job to seek justice and uphold the laws of this state and the Constitution. After an individual's arrest and their bail hearing 72 hours after their arrest, I had 45 days in which to decide whether I was going to institute formal charges for a crime in which that person would spend at most 6 months in jail. This is the period of time that we're attempting to change by passing HB 46. This is all pre-arraignment and has no effect on the prosecutor's ability to institute formal charges or the judge's ability to set bail. The current process as it stands is stacked against individuals who are legally innocent and must spend unnecessary time in jail using what little savings they have in an attempt to post bail and possibly lose their jobs while incarcerated before a charge is even made. Long pretrial delays also waste millions of dollars annually, and each day a person is held in jail costs about $52 on average. And we know that most people in jail pretrial are there for nonviolent offenses like drug possession or warrants for unpaid citations. We should not spend so much money to jail people arrested for these kinds of minor offenses. A more efficient system is a less costly system. As my colleague stated, we are sympathetic to the concerns we've heard, and we've come to this committee with several amendments which Chairman James referred to during his opening remarks, and we believe these address those concerns. So I thank you for your time, and I thank you for your consideration. Thank you.
Thank you, Ms. Willis. Representative Marcel.
I just really want to thank you, Representative James, for bringing this bill. Thank you all for working together to address these issues. I certainly support the bill, knowing that many people who are sitting in jail lose their jobs without ever being charged. Well, they're arrested, but not formally charged with anything. Housing is an issue. I've heard you bring up many of them, but a lot of times what I've seen is that the children, we oftentimes talk about the children that don't go to school, and we have parents that don't have other people to keep their kids. And so when you have a defendant, someone who's been arrested, that don't have the means, and this particularly affects people of poverty. People who have the means and the money, they write the checks, they get their kids out of jail, and they move on with their lives. And so this is a real issue in the state of Louisiana that we need to address.
Absolutely.
When we start to talk about the disparity in treatment of poor people versus those that have the ability to pay. Our system should not be designed such that if you're poor, you lose your job or you spend more time in jail versus if you have the money. It's about the laws of the land and protecting the people in our state. But at the same time, we cannot utilize our system and continue to have overcrowded jails. We frequently talk about overcrowded jails for people who are many times are misdemeanor charges. And so I've seen this as a problem for a number of years, and I'm just glad to support this bill going forward. The other, and I worked for a criminal defense attorney for a number of years, and the crazy thing is that when it gets to the number of days that they have to file a 701 motion, as soon as they file the motion, well, now they've sat in there all this time. Many times the DAs come in and don't charge the person, but they've lost everything that they've owned.
That's absolutely correct.
And so I certainly support this legislation, and at the proper time, I'd like to move it favorably. Thank you, Representative James, for your leadership, and thank you all for working with him on this issue.
Thank you, Reverend Marcel. Representative Villio.
Thank you, Mr. Chair. Ms. Garvey, were you involved in the criminal justice reform discussions in 2016 that resulted in the passage of criminal justice reform in 2017?
Was I in discussions or on
Yes, ma'am.
informal?
Just involved, whether informal or not, in discussion.
Informal, yes, but I wasn't on any boards or,
You would probably agree that the front end of the system, which is what we're talking about now, was not considered in those discussions, correct? Okay. And Ms. Willis, I was a prosecutor as well for a long time. And certainly I've talked to Chairman James about this bill and the realities of a system without all of those discussions and without the stakeholders ready to make these kinds of changes. You know what's going to happen. Would you agree with me that it's more likely than not that if these days cannot be met, that it's going to result in more people actually being charged with crime?
No, I
don't?
don't.
Okay.
I don't.
Well, I think that's the injustice that will actually result if this bill were to pass, if the stakeholders are not ready to meet those deadlines.
I appreciate your remark, and that's why we're willing to speak with everyone, and that we've done in the past. But I don't think that there will be more arrests. As a matter of fact, I think that there will be a reduction in the pretrial incarceration rates. This is something that was proven when it was done here in EBR, as Chairman James referenced previously. I think that it's also important that we recognize that the system players need to ensure that we fix the system. It's not up to the people that are being charged.
The system players need to be prepared to meet these deadlines, and the system players, much like the criminal justice reform, which I was not a part of, I was not an elected official at the time, they need to be at the table to discuss these matters at length in order to make it work. And that's my only point. But I appreciate y'all being here today. Thank you.
Thank you.
Thank you, Representative Villio. Representative Jones.
Thank you, Mr. Chairman. My question is, I understand that a lot of communications went forth with all the parties that be before you brought this bill, and the question is, are conversations still being had? Meaning, if this bill passes out of committee today, or we still talking with the DA's Association and all these other parties between now and the floor?
Most definitely.
Okay.
Yeah.
That's all I had.
I think that the conversation had been ongoing for quite some time. I think that Mr. Lambert and those folks can attest to that. If the bill gets out, I will certainly do my best to get to some type of resolution. And to Representative Villio's point, when we did do this in BR, there was an ADA that when I asked about, I said, "How's it going?" He said, "Well, it's okay. I just bill everybody." And I know he was joking because I know this guy, and he's not a DA that would not take his job seriously. But I do recognize what Representative Villio has brought, and I would hate for ADAs to go in there and see a timeline and rush to file charges to try to meet a timeline. So I'm definitely sensitive to working with those guys and change some of these red cars to maybe like light pink or something. But we definitely want to work with them
Because that's not the purpose of this bill, is to have a DA to charge people quicker. The time is for people who are not being who are just being held without being charged to get to a quicker resolution.
That's correct.
Right. So I'm sure the powers that be, if it comes out of committee, we'll still have these conversations and may take what Representative Villio and what you're saying into consideration.
Yeah, I mean, you worked on both sides, so you understand the seriousness of the issue, and and I've heard concerns about reports and lack thereof, and timeliness of getting reports. I think that that speaks to a separate issue and concern, but I understand that in this system it's all a cycle, and if one part is broken or not working well, then the system is delayed. And what's happening with this bill, that delay is causing hardships for families, and that's what I'm trying to correct.
All right, thank you, Mr. Chairman.
Representative Bacala.
Thank you, Mr. Chair. And I just want to speak to some of the practical aspects of the process, because it's something I'm familiar with. Certainly, at the end of the day, the primary protection against arbitrary arrest, I think, is the affidavit of probable cause, which has a very tight time frame. So if an arrest is made without a warrant, it is necessary to get the affidavit of probable cause signed quickly, and that's some assurance that there is evidence. Now let's talk about a non-capital homicide. We seem to have the misconception, or there may be a misconception, that at the moment of arrest, all paperwork is complete and ready to be turned over to the prosecutor's office for review. Let's just say that there's an arrest for a murder that happens today, all right? And the murder happens today, you make the arrest today, but you have weeks of evidence to collect, weeks of interviews to hold. So the only thing that a prosecutor might get on Monday, if forced to do so, is an incomplete document that says, look, we arrested him, here's kind of an oversight, I'll give you all the real details next week. So now we're forcing the DA to make a decision on whether to charge or not charge based on an incomplete report, because the investigation is ongoing. So now we're saying we want you to make a decision, but you don't have all the facts, but please make the decision now. Now that could result in bad decisions based on incomplete data. Now, as Representative Villio said earlier, the other side of this problem is, and I'll use this case. You've arrested somebody on Friday. Investigators have been up 24 hours straight. Now they have to sit down and write a report so they can get it to somebody, but they don't even they haven't even spoken to all the witnesses. Or you have 10 investigators out there. Some are talking to these witnesses, and others are pulling camera video from the convenience store down the street, and you're still trying to find this, and you're still picking up evidence on the scene because it's a complex scene. And they will get it as quickly as they can, but that investigative process, before they have a package that's truly ready to be reviewed, 10 days might pass. Let's just say you have a drug case, and the drugs have to go to the lab to be evaluated to see if it's really cocaine or it's some bunk that somebody's trying to sell as cocaine. But we're going to ask the district attorney to make that decision to charge him with cocaine when it might be powdered sugar, because we haven't gotten the lab results back yet. You've got to have the lab results, and I know that might be a good reason to say we need more time. Or, as a district attorney did in fact tell me this morning as we were talking about this bill, don't even ask me his name. It's somebody I first met today. It's simple. You put this burden on me, I'm charging everybody. I'm gonna look at the book, and everybody's gonna get charged before the 5th day. And we're not gonna review it, we're just gonna charge everybody. And that's what's gonna happen. So all of a sudden, the fix is gonna create a worse problem. Now, I do agree that some of these timelines could be tightened up. And I do agree that injustice can occur if we don't. And I do agree that innocent people it cannot be held in jail. It's just wrong. And the district, and look, it's not necessarily innocent, it's whether the district attorney chooses to prosecute the case. But I'm just afraid that the fix is going to create more problems, not only for the system, but I think the fix is not going to bring more justice. The fix is going to result in more injustice. When the DA is forced to charge somebody who was arrested with powdered sugar with cocaine because they don't have time to wait on the dadgum lab results to come back. Or the DA is going to have to charge somebody with murder before the investigation is even close to complete because they got to, or let them out of jail. That's the option. You don't do it in 5 days, you get out of jail free card. We got to work on this bill. I think there's some middle ground we can find. But this bill will result in more injustice, in my opinion. Thank you, Mr. Chair. I'll invite your comments.
No, thank you, Mr. Vice Chair. And I think that, in your comments, the most problematic thing is, because I mentioned someone that said it to me jokingly, but I think the most problematic thing that I heard is that a DA in this building told you that he would just go and bill everybody. That's the most troubling thing that I've heard today. Mm-hmm. And for me, that speaks to, we're putting responsibility on people that haven't been educated, hadn't been trained. All labs, tax dollars go to pay those folks. Investigators, tax dollars go to pay those folks. ADA's tax dollars go to pay those folks. Joe Blow on the street, we are asking him to suffer because all these folks that he's paying by his tax dollars simply don't want to do their job faster. And I recognize that the days may be unreasonable, but I think that the problematic thing is for somebody to admit that he's sworn that he would just bill everybody.
I think that's the only practical solution when he says he doesn't have the paperwork yet, it's not in, he doesn't have the lab results back because it's not back. And I think that, and let me tell you, he said it very reluctantly and very, very much did not want to say it. He said, that's all I can do. That is all I will have at my disposal to do, because it's not practical in 5 days to expect the reports to get to us, to be able to be reviewed, to give ample time to actually spend time on the 100 cases you get on Monday morning, and try to get it right. So the fact of the matter is, it wasn't something they were proud to say. It was something that said, I'm stuck in a hard place. Let everybody out of jail on Monday morning or file charges and trust that the judge who signed the affidavit of probable cause got it right. So they're gonna entrust that the affidavit of probable cause, which was signed by a judge, is correct in making the assumption that the charges were justified or probable cause existed. It wasn't something they looked forward to doing. It was something that they said they had to do because that's the only option they would be left with. And I just want to make clear that it wasn't something the DA was happy to have to feel required to do. Thank you, Mr.
Yeah,
Chairman.
and I get it. And I think the other piece with police reports, as a criminal defense attorney, I've read some police reports that almost sound like they should start with "once upon a time." So I get that the issue of adequate police reports is something, because I see some that I deem laughable. So I understand that concern. But let's get to some other comments. Representative Muscarella.
I won't beat the point, but basically at the end of the day, we know that 45 is too long and 5 is too short. So we need to come to some sort of compromise where everybody's happy, because I do think there needs to be some kind of change. But that's all I need to say.
Thank you, Rep. Representative Villio.
I think that's a mistake. Sorry.
Representative Bryant.
I'm on the same thing as Muscarello. Have the DA's office, have y'all spoke and have y'all came up with some other ideas of time periods that would work?
The
The conversations,
We've reached out. We're back and forth. We have collegial conversations about this, but we haven't reached any numbers. But I think it's something that both of our organizations would definitely be willing to sit down and talk about.
Time periods. All right.
Yes.
Can I hear from the DA's office?
I think we have a few that have, we got a couple that want to talk, so we have opportunity to hear from them.
The DA's.
Yes, Representative Nelson.
Yes, ladies, thank you. So my question would be: do you have any data on what the average in for different charges across the country? Obviously, each state has the same problem. Do you have any idea what the I know it's probably broken down by the seriousness of the crime and stuff. Any idea what the average is across the country?
I know that there's about 20 states who do everything within less than 30 days. So keep in mind, obviously, we provide for 30 days for the homicide charges in our bill. So I think there's definitely a lot of states that are doing it much more quickly.
And so, what about for the minor? I mean, I think obviously murder is going to be a rare charge versus
Well, I mean, New York is 5 days. Colorado 10 days. I mean, and I think that's for everything. I think it's Connecticut, although it's not always apples and oranges. So sometimes it's a little hard to explain because like for example, in New York, they take everything in front of a grand jury, right? So it's not really the same, but I mean, there are definitely lots of states that provide for very short periods of time.
And do you have any idea what percentage of people that are arrested, what percentage of those people are never charged in Louisiana?
I don't know if we have that or not. It might have been in their report from last year. I don't know, but
No, but I'd be happy if we are able to obtain that information. I'd be happy to update you. If also I can add, currently Louisiana, we are one of 8 states which allows for a charging period as long as 120 days. So we're kind of like an outlier. But I would tend to agree with Meg that a lot of other states are I guess charging for minor offenses in a period of 3 days or less.
And the other question I would have is, what are the, for that percentage of the population that never gets charged, how long do they actually stay in jail before they're released? Or until they keep them for the maximum of 45 days?
Yes, sir.
yeah.
I mean, so that would be, in my mind, that's egregious. I mean, I agree that, I probably the DAs have the point that, hey, look, it takes some time to process this paperwork.
Right.
But if you held somebody for 45 days and then never charge them, that's egregious.
I would agree with you.
And
So-
oftentimes people are held for a long period of time. For example, like they're arrested on a felony and then they're held for the 60 days. And then, maybe they end up being charged with a misdemeanor. And it's a misdemeanor for which they would never have gotten jail time in the first place. It's a misdemeanor that would have been resolved in another way. So all of this time, out of their lives and their families' lives and all of the money that we're spending, right? It's just a waste because these are not people that would have gone to jail otherwise.
Yes.
If I could just put it into some perspective, if you think about it, so there's a 45-day period for minor offenses like say a first possession of marijuana, right? So from the time that I have that I would receive the case, I have 45 days to make a decision, and then there are 30 additional days to set a bail, not a bail hearing, an arraignment. If you think about it, that individual would have spent half of the sentence, because for a first offense marijuana, we're thinking 6 months, up to 6 months, right? So that individual would have spent half of that period in jail. So a lot of the times individuals are just coming up for arraignment and pleading guilty just so that they could go home. And it's something that I've witnessed. So I appreciate your question.
Yeah, I think that, I mean, in my opinion, I think having some of that data, which I understand, having my own issues with trying to obtain any kind of data on this
Exactly.
is basically impossible. So
Yeah.
I understand the difficulty in that. I think that would be really helpful in making these decisions. And I understand if, unfortunately, nobody knows the answer. I would just say, I kind of I think echo what I think some of my other committee members have said, is that this is something we need to fix. So thank you.
Thank you.
Thank you, Rep. Nelson. And just, I want to point this out on the fiscal aspect, and I'll make sure that I get you guys a copy of the ACLU report that was released last year. But they estimated, it's $52 a day to house. So annually, statewide, we're almost spending about $290 million housing folks that, again, have not been charged. I know I could think of at least 3 things that we could do with $290 million, aside from holding people in jail that haven't been charged. So we don't have any more questions, but we do have several green cards. Terry Landry Jr., we had 170 emails in support. Terry Landry Jr., Southern Poverty Law Center, Will Snowden, Vera, Flozell Daniels Foundation for Louisiana, Bridget Nealon, Stand for Children, Gina Womack, FLLIC, Cameron Westbrook, Americans for Prosperity, Liz Mangum, Smart on Crime, Jay Johnson, Young Republicans, Scott E. Payton, Right on Crime, Katie Hunter Lowry, Louisiana Survivors for Reform, Dominique Martin, Operation Restoration. We have Ivy with Vote. We have Ryan Haney with Vote, Telly Medina, Southern Poverty Law Center, Keith Morris, Vote, Michael Kuhan, The Promise of Justice Initiative, Kelly Garrett, Vote, Renee Smith, Vote, Danielle Duson, Vote, Clarice Caligos, Vote. Y'all bear with me. We also have Liddell Henderson, Vote, Ivy Mathis, again, Vote, Tommy Jones, Vote, Jennifer Harding, Vote, Vanessa Spinazzola, Chico Yancey, Riley Lloyd with Vote, Shuteacher Sapatu, Louisiana Criminal Defense Association, Suteacher Sapatu, ACLU, Will Harrell with Vote, Linda Franks, Reverend Alexis Anderson, Rodney Braxton, Southern Poverty Law Center, Peter Robbins Brown, Louisiana Progress. We have M. Burns with Vote. We have Jacqueline Germany. Hey, Miss Germany. How you doing? She's a staple in Baton Rouge. Y'all got to give her a shout out. Miss Germany practically raised me, and probably Denise too. But Denise a little bit older than me. But I think Miss Germany raised her too. Monica Gerhardt, City of New Orleans. Kiana Galloway, Vote. Turner, Vote. Wendy Mathern, Vote, and David would Vote. Now we'll bring up the pinkish cards. We have present in opposition would like to speak. We'll call up Mr. Lauren Lambert first, and Bo Duhay with the 16th DA's Assisting District, New Iberia. Marcus, you told him to come.
Good morning, Mr. Chairman and
Good morning,
members.
Lauren.
My name is Lauren Lampert. I'm the Executive Director of the District Attorney Association. And man, I didn't want my first appearance in ACJ this year to be read. I dumped a bunch of green cards in this committee today. Just seriously, first let me commend the chairman. He everything he said is accurate. He has been in constant communication with us, as have some of the stakeholders. And I wish that I could sit down today and drop a green card on this bill. What you're referencing here is not a DA problem. You're asking us to be the solution to a problem that exists from the top to the bottom of the criminal justice system. If I were able to drop a green card, it means we had competent, well-staffed law enforcement agencies who were generating the information we need timely. We had crime labs that were well-funded and well-staffed competently that were generating the lab reports that we needed. We had competent, well-staffed public defenders who were on the front end of these cases, pushing them to a head, which is something that helps us, believe it or not. We had competent and well-funded judiciary and judiciary staff who could move these files in the time frames that we're talking about here. And then last but certainly not least, you had competent, well-staffed, adequately funded district attorney's offices who could move the files. There's nothing about 5 days in and of itself that is problematic. It is the 5 days on top of the system that is being laid upon that is the problem. And everybody has kind of recognized this issue. It's not that police are incompetent or lazy. It is they're jammed up and understaffed right now, right? And look, there are some lazy prosecutors, there's lazy police, there's lazy judges, maybe even one lazy legislator. I don't know. But generally, we're all showing up to do the right thing for the right reasons and kind of push the wagon in the same direction. We enjoy what we do and the process, and screening really, I mean, those of you who have done it, I know Rep. Villo has done it. Screening is where the rubber meets the road on criminal cases, and an adequately screened case is where justice is found. We try to screen at the lowest common denominator. We try to screen in a method, in a manner that we know that not only can we prove it beyond a reasonable doubt, but it brings justice to the situation. And there's a lot of variables in there, not just a crime, but the offender themselves. Right now, we do have some safety valves, right? And within the 45-day to 120-day system, and those safety valves were kind of referenced. It's a little more than a line or two that a judge signs off on with respect to probable cause. I will take it. For those of you who have never seen it, I have seen judges reject probable cause affidavits. Okay, that happens. That's a real process. We also have, and that has to happen within 48 hours. There's also the 72-hour hearing where counsel is appointed and bond is set. We have Article 316 of the Code of Criminal Procedure that has many factors that determine whether somebody is eligible for bail and to what level that bail should be set at. Part of what we're talking about here is a bail problem, to be quite honest with you. You know what I mean? But really accurately determining who is likely to abscond and who is likely to reoffend while they're out. Those are the people we want in, and everybody else we're okay with, right? Once the public defenders are appointed and they're overworked and understaffed as well, kind of the discussion process. And I don't know how many times I've answered the phone as a prosecutor. I'm waiting on the lab report. I'm waiting on this. I'm waiting on a statement. And we are in a pretty constant process of screening these files as they move. We got really good at it during the pandemic, and I hope that we can sustain that because, as you know, most of you know, our local jail population plummeted during the pandemic because we were putting a lot of efforts there. But quite frankly, we've since had the huge pandemic backlog that this bill would be superimposed upon, and it's real. It's a real backlog. And a 42% increase in homicides in the last year that shows no signs of slowing down. We're superimposing that upon this discussion as well. So I say all that to say this. You're right. There need to be some improvements, Representative Nelson, and the data you want is data that is not really as simple as you said. There are a lot of the people that are ultimately rejected. They're processed in and processed out. I don't want to. And we really do need the numbers. I would be shocked. I can't say that there's no misdemeanants are spending 45 days in jail if they're only there for a misdemeanor charge. They're not. They may be serving 45 days once they're convicted. That's a different story, right? We're talking about pretrial here. One of the most effective things I've seen, and I don't want to co-opt the bill, but I'm just saying we're constantly looking for best practices, is what we call a look-back screener. And that is people within the system, and sometimes it's in the DA's office, sometimes in the judge's office, sometimes it's actually in the public defender's office, who gets a jail list every day and makes sure nobody slips through the cracks and is hounding police for reports, hounding crime labs for lab reports. So I say all that to say this. We recognize that, and we join with you in asserting that no person should spend one more day in jail than they should. How do we get to those who should and shouldn't? How do we discern those without a way of jeopardizing public safety? I will tell you, as the bill was originally filed, and I haven't had a chance to look at all the amendments, but I have been told about them. They weren't sprung on me. I'm not saying that. I just hadn't had a chance to read them. It does remove some of the concerns, the Article 66 problems, and some of the things we don't have a problem with about the appointment of counsel and things such as that. We're for that, right, actually. It helps us. But the timelines, look, we can make it 5 days. We can make it 500 days. It's not going to solve the problem that you're wanting to solve. And I'm not discrediting the efforts on behalf of the chairman or the advocates bringing this position. This bill doesn't solve that problem. Until we really, and Rep. Villo and I have not had this conversation, but she nailed it. Until we take a real honest look at our pretrial side, on the front end side, which includes some of the bail stuff, which includes law enforcement and crime lab availability, we're really putting a Band-Aid on a bullet hole. So I'll answer any questions. I brought, I didn't bring, our president.
Marcus brought them.
Bo Dewey. And I'll turn it over, and thank you for the opportunity to work with you, Mr. Chairman James.
Thank you, Mr. Lambert. And look, I certainly appreciate all of the conversations that you and I have had on it. Lauren and I, members, we talk very frequently, so I appreciate you.
My name is Bo. It's spelled B-O, Dewey, D-U-H-E, and I'm the elected district attorney in the 16th Judicial District, which is Iberia, St. Martin, and St. Mary. And yes, Representative Bryan is one of my people, and he's promised to be nice to me today, so thank you. I want to thank Mr. Chairman for bringing up this issue. I appreciate all the members of this committee. One good thing about having Lauren is that he doesn't leave me with a whole bunch left to say, except that, you know, the reality is this is a staffing and hence funding issue. You know, someone mentioned about New York. Well, New York does it 24/7, and they're having to pay for 24/7, and we don't have that luxury. As an example, you know, you go through this process. I've got 13 different law enforcement agencies in 3 parishes, all very good, competent. 3 sheriffs out of that. 14, 3 sheriffs out of that, and it's difficult. I'll give an example. I had one of my police departments who there was a murder of a young man, a young high school man, and it involved multiple people. And that police department, it was a city in New Iberia, conducted 70 interviews. 70 interviews. And through that process, we have to wait and get that information. I'm hard on my ADAs. I'm like, you know, you need to screen that file and be hard and honest with that screening. We just don't charge people to charge people. You need to be honest with that screening process and make sure the evidence is there. Because, of course, we're going to, from that different level of probable cause, our ethical obligation is to be satisfied that a reasonable judge or jury, that the evidence that is admissible supports all of the elements beyond all reasonable doubt. And that's a big jump. I mean, I think it's, you know, it's a pretty big percentage of cases we reject. And that takes time. And it's very difficult. But we just don't have the staff. Because you got to remember, through all this process, we've got court going on. We've got, you know, other court hearings going on. We have other things going, everything from criminal matters to, you know, representing public bodies. And it's just we don't have the staff to give it. I would love to have a caseload per ADA of, you know, 20 cases, 30 cases, but it's not practical. Right now, out of all of my felony ADAs in 3 parishes, they're averaging anywhere from 280 to 350 cases. My misdemeanor ADAs are handling roughly 1,700 cases per ADA. It's just impractical to do it in such a quick time frame. So that's my take on it. It's just it's there's an issue here, right? But it's how to correct it, and it's staffing and funding of that staff. So thank y'all very much. I appreciate the opportunity to come before you.
Thank you, sir, and welcome to the committee. We have a few questions. Representative Marino. Well, we have several questions.
Thank you. Yeah, I agree exactly with a point that Mr. Lampert made, is that what we really, you're not going to have this problem of having a lot of people to have to screen in a short period of time if the people are not incarcerated pre-trial. I think he's exactly right, is that, you know, along with this discussion, we should also be having a discussion about how we do bail in Louisiana, because bail is supposed to guarantee your appearance in court, and you shouldn't be held in jail unless you're either a danger to yourself or the community, or you're a flight risk. So a lot of times we have this problem with a lot of people in jail pre-trial, because we haven't really addressed or changed the way we do bail, and there's very high bond sets. So the people that are remaining in jail that you have to do this screening within these time periods are either people who have no resources, or even people who do have resources but can't afford to pay the bonds I mean, I've had, cases that I represent people on where they're charged with possession with intent to distribute small amounts of pills, but several different pills, and there's a $25,000 bond set for each scheduled drug, and then you're sitting in jail because your bond is $100,000, and you either have to pay a bail bondsman 12%, or you have to put up a property bond or something else. I mean, and there's a lot of people that are in jail that don't need to be in jail because they're not a flight risk, they're not a danger to the community, and they will appear in court. But be that as it may, because what this bill is addressing are the people who are left in jail, and we're not talking about charging them or not charging them, and we're talking about releasing them without a bond obligation. So even if you had a shorter time period, if you have a first offender charged with a possession offense, which is probatable, why would you need to automatically file the charge against them to make sure they have a bond as opposed to releasing them? I don't think every offense that someone's in jail for would automatically, the DAs would automatically have to charge someone immediately. But and we got a lot of different time periods that we're talking about too. But what this bill does have is there's still a safety net in here to say without just cause shown. So even on a homicide case, someone is not going to be released without a bond obligation after 30 days if you go into court and tell the court that you are in the process of reviewing evidence, or there's a just cause, there's a safety net in there for all of these, even for misdemeanors. Right? I mean, it's
the original bill wasn't. I think the amendment restores the safety net, although it may impact the Varmal case, which you're familiar with. Yes, but if Bo pointed out if we're now spending 30% of our time in show cause hearings, right, we're taking away from our time to screen and develop these cases and move the docket. I mean, again, I'm not saying that's not worthy of conversation and discussion, but it is not going to solve the problem that everybody acknowledges exists here today. And amending 701 is not the solution to the problem you're discussing. And if the person is a first-time offender, even a second offender, possession of whatever other than fentanyl, I think we all agree that that's different in kind, not degree. I know Representative Fontenot does. I don't know that they're going to be sitting there anyway, and in most of the practical application of the pretrial, release that's going on. But very solid points. I did want to say, and I made some notes and kind of got ahead of myself. We're not really an outlier here. Louisiana is about the middle of the pack in these timelines, some higher, some lower. But I will tell you, those with the low, with very low, and I think Colorado, she mentioned, is one, their time doesn't start to run until they received a police file. So that's the difference, right? So once the police file starts running, I do think you can put pressure on prosecutors to move the case. But we don't want the police rushing, right? Because we get blamed for all of those mistakes as well. So, look, thank you for the conversation. Very salient points, Rep. Marino. The safety net, I think, is back in there, but that could create some problems in and of itself.
I mean, I would, I think the time periods that are in the bill right now are a little ambitious on 5 days and 30 days as far as being able to adequately do your job. I think I don't agree that that's enough time for a lot of offenses. But I would rather us today amend those time periods and keep this bill going, because right now, 45 days on a misdemeanor, 60 days on a felony, and 120. I think we can adjust those time periods, or maybe even have a number that we can live with right now, and keep that safety net in where we could keep this bill moving and continue to work on it.
And I appreciate your willingness to work. I would ask you to hear from some of one of the things, and I think Ms. Garvey pointed out, is that Louisiana is so unique in geography and demography and everything else, but we have jurisdictions, quite frankly. I think one of them's here. They have 3 parishes. They have 2 judges. I mean, you understand the difficulty. They're going to have criminal court maybe 2 or 3 times a year in each parish of any substantive nature. They're doing 72-hour hearings. I'll let them talk. But so there are a lot of unique problems, and I'm not saying the exception should define the rule, but I'm saying we really need this committee and the members who are voting on this really need to understand the complexity of what goes on in different practices in different areas of the state. So, thank you.
Thank you.
Representative Bacala.
Actually, I thought of unpressed, but I'll ask the question.
Well, I could go to the next person.
Okay. Go ahead.
Seriously, no, go ahead. You sure?
No, I just, perhaps you can answer a question, generally speaking, asked by one of my colleagues earlier. The number of cases where an arrest is made but charges are not filed. Do you have just a general sense of what that percentage might be, even though we don't have any hard statistical? I was asking the DA.
I think, and we're talking about arrests, not the ones that are necessarily incarcerated, but it's my understanding on average about 40% of the cases charged in Louisiana or arrested in Louisiana aren't charged. Now, there may be some of those that go into a diversion program or something where you're not going to file a bill, but it is a substantial part because it's a higher level. And I'll be honest with you. I'm hard on my assistants. I mean, get everything and make a hard decision because the implications from that point forward are far-reaching for that individual.
I guess a better question might be if you throw pretrial diversions into the mix, but I guess the better question, do you have an idea of how many cases that you decide not to file charges in where the decision is based on a lack of evidence?
That's a much lower one. Particularly, it's been my experience, and I can just speak for my district, is the ones you're talking about that are in jail or in there for serious offenses. We don't have a lot. I'm not aware of any misdemeanors that are in jail solely awaiting, a bill to be filed, and certainly not low-level felonies. We're talking significant or somebody who's, we got people right now because of the pandemic that are out for burglaries pending on 3 separate bonds and get rearrested again. And that's a problem. And we're still sometimes waiting on reports on the 2 first ones because law enforcement agencies, when they get down and they have an event like a major crime, they're over there and they're working, and guess what? There's another one the next day. So they got to drop everything here, go work on that one. It's just it just becomes problematic to be put in these short time frames.
And I guess I'll ask Mr. Lambert, would you be willing to recommend some time frames that you think improve upon where we're at now, but are workable in a practical sense?
We're always open to discussion, and you know that. I think, but I do think it would be disingenuous for us to just say, we'll take 10 days off or whatever and give us that escape hatch on the backside and go. We're still not, and that may get us through this day in this bill. We still are not addressing the underlying issues that are causing the problem. And I'm not trying to not answer your question. We're always going to come to the table and talk. And on the other side, I think anecdotally about 30% around the state, and I'll speak to Representative James did a very accurate job of explaining what happened in Baton Rouge. And it didn't really fail for any one reason. Primarily, they ran out of judges, I think, to be able to hear the cases in the period of time. And those weren't really arraignments. They were what they called first appearances to help screen them out. But it did result in, and I think they'll tell you, it did result in them charging more cases than they probably would have on the other side of that because of the abundance of caution when somebody has a serious criminal record, right? And you're worried we're going to default to the public safety position here. So when that happens, you're putting more of a burden on the public defenders, which then puts another burden on the whole system. So I'm not saying we're doing it perfect. I'm just saying we're very sensitive to all these issues, especially in the screening process.
Yeah, and I think Representative James is trying to seek a better, ensure that people don't stay in jail who shouldn't. So I think all of us can get behind that, but making sure as well that protections are left in place and that we don't do more harm than good, I guess, is the balancing act. Okay, thank you, Mr. Chair.
Thank you. Representative Vilio.
Thank you, Mr. Chair, and thank you, gentlemen, for being here. Have there been discussions prior to now about a task force to discuss the front end issues?
No, but I mean, not that I'm aware of. I can't say, not that I've been a party to. I can tell you, though, Chairman James is right. In the off season, and I guess he's just independently wealthy, but even in the off session, he's constantly bringing ideas and floating them. So it's not, I don't know of an official task force, but I do think there has been an ongoing discussion around things that are all bundled up under this. And I think we all recognize there are problems. It's just y'all are trying to solve a bunch of more right now. So,
like you, Mr. Lampert, I appreciate the conversations I've had with the chairman on this bill, and I am concerned of the injustices on both sides, and it's that very default to public safety that I believe will result in more individuals charged by bills of information as a result, and not callously. But because of that public safety concern based on either the crime or the prior criminal record, etc. And I'm in the unenviable position of being in opposition to my chairman's bill right now, particularly with the days that are outlined. And I wish there was some compromise in terms of days that we could work towards, and I think he knows I feel that way. I hope he knows that I feel that way. But so if there's any discussions we can have on that, I'd certainly appreciate it.
we will certainly continue to discuss it.
Thank you.
No matter what happens, we're going to continue to work with you and the chair.
And you have my commitment as well, Representative Vilio, and you know, this legislature has discussed a lot of these things, from bail to funding the technology. That we've been dealing with fines and fees for 3 years. I don't have another 3 years with you all. So I don't want to adopt the same hurry up and wait mentality that we have on other issues. And I think that if we get something here, then I think that it forces folks to the table to address the other issues. And I could be singular in that thought, but I know that there are a lot of things that happened in 2016, but there are a lot of things that have been studied and continue to be studied. And I think that if we get moving on something, I think it brings other folks to the table, and it forces them to address a lot of the. And I mean, even with our clean slate discussion, we've uncovered so many different issues that we have in the state. And I know that the majority of the folks on all sides want to do the right thing, and not feel pressured to do the right thing, or fearful of, you know, victims. And I know that we haven't talked a lot about victims, but there are some victims advocacy groups. I know STAR is in support of the legislation, and they have some thoughts about just, you know, this process in terms of, you know, the standpoint of a victim. And I know that we all have to be sensitive to their plight. Representative Nelson.
Hey, Lauren, thanks. I appreciate it. Sure. So it sounds to me like both of you are saying that this isn't it's not impossible, that it's just a funding question, right?
It really is.
It's just money. I mean, my opinion is that we shouldn't keep innocent people in jail because we don't, as a state or as local government, don't allocate the money to adjudicate their cases timely, right? I used to watch Cops as a kid. You know, I think lots of people probably do. I mean, many people probably think I'm still a kid, and I probably still fall in that category, but like every episode, right, they end and it says you're innocent until proven guilty. And then we just said that about 40% of the people are never charged. So, I mean, not only are they innocent until proven, like they were, I mean, at least in the eyes of the law, they were innocent. They didn't have the evidence to do it. So these people we're locking them up and we're keeping them in jail. And then, I mean, you guys are telling me that it's just because we don't have the money, or we don't allocate the money. I mean, the truth is the state has the money. We spend it on other things, but we don't give it, I mean, we don't give it to you. And I mean, in my personal opinion from you guys telling me this, it's like, really, we have to put them under the gun to say, actually, this is something that you need to fund. And I think if we continue to allow it to be 60 days and 120 days, they're never going to be under the gun to come and say this is something we adequately have to fund. And so that's my opinion. I 100% agree with you that it's a funding problem. It's not practically impossible for us to adjudicate these things within 5 days or 10 days, whatever it is. Maybe 5 days is maybe too expensive a burden. We have to double the size of every office in order to achieve that. That's possible. But I think fundamentally we really have to make it a priority to fund these things. And I don't know if we kick the can down the road and say we're going to have a study, we're going to study this, we're going to study everything forever. Will anybody ever say, hey, let's fund it? And I'm with you 100% on this is something we need the money. So I have a kind of a project management engineering background. I'll tell you, every time I teach a class on that, I tell them every time you give somebody tell somebody to do a task, you have to give them a deadline, because whatever task you ever give them, they're going to make sure that it fills up that deadline, right? And so I think, and to me, at least to some extent, these timelines are that deadline that we work towards. If you tell me if you tell me, hey, I have to finish this project in 45 days, I'm going to do it in 45 days, maybe 44. If you tell me I got to do it in 15, I'm going to do it in 15, because that's when I get told to do. And so to some extent, I think in order to find out what kind of resources we need, to what kind of backlogs that is, we can sit and study it and throw around numbers for forever. I mean, we all know how discombobulated this whole system is, and finding those numbers is very difficult. And I think it wouldn't be until we set those concrete deadlines to say we're going to do this, because not only is it the right and just thing to do, but I think if the reasoning behind it is that we don't have the money, I think it's just fundamentally wrong. And I'll go with you over to the Appropriations Committee, and I'll say, look, if we spend $150 million a year on film tax credits, if we we fund all these things that are absolutely not priorities and fundamental functions of government, we need to spend money on this. So I'm in favor of this bill just because it's going to push that conversation forward. It's not because I think you guys, it's not because I think you have the resources or I think you need to be pushed. I think it's because we need to push this body and the justice system in general to come to the table and provide the money in order to make these things happen. And we can't keep putting that on the backs of innocent people, or just the people who get arrested, whether they're innocent or not. We shouldn't put it on their backs to decide, or to bear the burdens of what we should have to do. That's my opinion. I appreciate your testimony, and I really agree with you. Thank you.
Representative Bacala.
Quick question, and I will speak to that. We talk about extra funding. Y'all spoke earlier about the DAs would need to expand your staff. The indigent defenders would need to expand. We need more judges, but you also spoke to the police maybe having too many tasks. So they're investigating 10 burglaries. So we also need to up the funding for police.
I hope I said law enforcement and crime labs.
Yeah,
No, it's true.
crime labs. We're talking about if we're talking about funding, it's not just one little chunk of the puzzle, right?
It's the whole puzzle.
Okay, and Mr. DA, I have a question for
Yes,
you.
sir.
You said and it wasn't about innocence or guilt in your office's opinion about the probable cause, but you said you divert a lot of cases such that about 40% are never charged. Right. And a lot of that, it sounded like, has to do with pretrial diversion.
That's correct. It's not an issue of guilt or
If tomorrow if this bill was law, what would happen to that 40%? Would it go up or down? I just need you to tell me what you think.
Well,
Whether it's pleasant or not, let's hear the truth.
I mean, if it's ultimately we're going to make the right decision, and whether that's within 5 days or 10 days or after that, I don't think it's going to change the numbers on what our philosophy or my philosophy, my office's philosophy is on who deserves that second chance, who deserves that opportunity to go through diversion and not have all of the obstacles put in the way that can follow them down the road. So I don't think my percentage of cases, but being charged,
I'm trying to.
frankly, a lot of those cases are not going to be charged. I mean, are not incarcerated anyway. It's low-level felonies and misdemeanors. So I don't think it's going to affect a lot of that.
Okay, well, I would have thought the answer would be that not given the opportunity to not only review probable cause but also review suitability for pretrial diversion, more would be charged and less would be initially given pretrial diversion. I would have thought practically that might have been the answer, but
That not because of the fact that those that enter in those diversion programs are generally not incarcerated anyway. You're talking
but I
low
think we
levels.
also have restrictions on the not incarcerated.
Right,
Also
right. Right.
I would hope that we could come up with the right number that helps ensure that people don't stay in jail longer than they need to. But ideology, being one thing and practical application being another. We need to find some place that actually seeks to accomplish the goals of the bill. It doesn't actually, result in negatives and more people being charged than should be because of the lack of funding. And if the funding would, do you put the cart before the horse? I guess it's a tough question. I do think justice is ultimately what we're trying to do. But thank you, Chair.
Thank you, Mr. Vice Chair. Representative Marino. Quickly.
Very quickly. I just want to say that, again, I don't think the time period of 5 days is right. I don't agree with the 5 days. I think it's too fast on a lot of things. But I am in support of the bill because I also think that there's room for us to negotiate between now and the floor, because I also think that 2 months of sitting in jail waiting to see if you're going to be charged with a crime is too long before a decision has to be made, or at least even come into court and ask for more time. So that just wanted to give you my thought on why I'm in support of the bill as it stands right now. But I'm definitely want to continue to work with y'all on possible fixes.
Thank you, Rev. Marino. And we have some other cards in opposition that don't want to speak. Darren Almond, Jefferson Parish, Sonny Funk, Jefferson Parish, Norma DeBose, Jefferson Parish, Kurt Wall, 21st JDC, Robert 2, D, I think that's the 4th district, in Monroe, Chris Nevels again, with Winfield Parish. We had another green card come in. Victoria Lowry is present and in support, would not wish to speak. And we have one white card. Mr. Renata, I know he's present and wishes to speak. We do have to get to the floor at 1, and we have a member that has a flight to catch. So we're trying to move forward.
Thank you, Chair.
And we have a couple more bills. Thank you, Mr. Dewey, and thank you, Mr. Lambert.
Mr. Chairman, members, my name is Michael Renatza. I'm the Executive Director of the Louisiana Sheriff's Association. We submitted a white card in line with what was presented to you by the District Attorneys Association, and our discussions with them have been primarily on the timeliness with the processing of evidence. And there's been considerable delays as of late, in particular in this region, that has caused concerns for our organization, whereby we've asked for a meeting on the 12th of May with the district attorneys to discuss common concerns pertaining to the processing of evidence. And we will be meeting on that as an organization on May the 4th, as directed by my president, Sheriff Ard. But we wanted to state, in addition to what was just mentioned, that has to do with the severe timelines that would be imposed on the district attorneys, and as stated by Representative Marino and others, I think Representative Muscarella, 5 days is way too short when all the factors have to come together, and it really causes an undue burden on the district attorneys. On the issue that was raised by Representative Villio, and I know Representative Marino remembers many conversations with me in the past, at the conclusion of criminal justice reform in 2017, we, as an organization, the Louisiana Sheriff's Association, we asked the Pew Research Group to come back and finish the job that they started. Because what we said, you've looked at the system at the tail end, you've looked at corrections, you've looked at the problems, and why we have such a a high population within our DOC population, which was the highest in the world. But we didn't look at the input into the system. And our concern 4 years ago is the same concern today. The amount of the population within our jails that have not been sentenced, that are awaiting trial. And we have no bearing on that population, but we have to house them. So we asked for a fix. And we didn't just look at bail. We looked at all the elements of the system. And one thing that Mr. Dewey said that is 100% correct is that there's numbers problems within the staffing and district attorney's offices. There's numbers problems within indigent defense. There's numbers problems across the board. You heard about judicial districts that don't have adequate judges. So if we're going to fix the problem, it's not just money, Richard. It's not just money, but you have to attach to the money that you expend to fix the problem the right performance indicators that's going to get to the meat of how we're going to reduce those numbers. How we're going to have the system operating more efficiently. So we don't just need numbers. We need the numbers to work toward the goal of fixing the problem. So we were frustrated. We met with the governor, we met with the secretary of the Department of Public Safety and Corrections. We met 4 years ago with the president of the Senate, the chief judge, the chief justice of the Supreme Court, the Speaker of the House. We asked every entity to join with us in asking the Pew Research Group to come back. I need to tell you that the decision made by Pew in their response was to us that they didn't see that there was enough appetite at the time to have sufficient input for the process, as was the case with criminal justice reform. So it behooves us as a state to come together and fix this problem, or it's just going to be forever a piecemeal approach, looking at one thing, one factor versus the other, when all the concerns really need to be reviewed. Thank you for your time.
Thank you, Mr. Renassa. And I know you're real passionate, but I'm asked that when you refer to the members that you not refer to them by first name. So that's Representative Nelson. And I know you, yeah.
My apologies.
Yeah, and we have certainly we could continue to talk about criminal justice reform and all of the different things that we can go. I know you didn't, but just for those folks that are watching, I want to get to a point where we can, I'd like to close on the bill. There aren't any other questions. Members, I would actually just like to adopt Representative Nelson's last statements and adopt that as my closing, and again, reiterate if the bill advances, of course, I will have continued conversations on every aspect of the bill with the stakeholders. Representative Marcel has already made a motion to report favorable as amended. Is there any objection? Representative Bacala objects. Madam Secretary, please call the roll for the vote. A vote yes is to report as amended. A vote no is to leave the bill in this committee.
Representative Bacala? No. Representative Bryant? Yes. Representative Fontenot?
No.
No. Representative Gudo? No. Representative Jones?
Yes.
Yes. Representative Marcel?
Yes.
Yes. Representative Marino?
Yes.
Yes. Representative McKnight? Representative Muscarello? Representative Nelson?
Yes.
Yes. Representative Seabaugh? Representative Villio? No. Do you want to vote? 5 yeas, 4 nays.
Thank you, members. With a vote 5-4, the bill advances as amended.